Hello, my Secured Transaction students. Welcome back to the next episode of Secured Transactions, where we explore Article 9, how to create security interests and enforce them. Today we are doing assignment 11, on buyers. And we have talked about buyers a great deal already. They've popped up in our problems of various types, and so the concept should be familiar to you. There are two types of buyers that we've become acquainted with. That is the buyer buyer in the ordinary course of business, a BioCob, and that is a situation, a retail situation. I think is a good shorthand way to express it. It's where you buy something from a seller who's in the business of selling that type of thing. The other type of buyer is the one that's not a buyer in the ordinary course of business, who we'll just call a buyer, a regular buyer, if you will. And that's someone who purchases goods, but from someone who doesn't ordinarily sell those goods. And the type of scenario that I have repeated is a factory that is selling its used equipment, its used robots that it has on the factory floor, to another factory, a competing factory. So it is a sale, purchase and sale of the robots, but the buyer does not become a buyer in the ordinary course of business. And it's important, first of all, following my mantra of first identify the parties, then apply the appropriate priority rule. It's very important to be able to distinguish between a regular buyer and a buyer in the ordinary course of business. So that is the first step. Okay. So where else should we go? What else is at the core of what we are discussing today? We're going to look at three provisions of the UCC. We're going to start with 9.315, and then we're going to move to 9.317 and 9.320. Let me share my screen. We'll take a look at 9.315, which really sets the stage for this discussion of buyers. Okay. And this is the language that I want us to focus on here in 9.315A. A security interest continues in collateral notwithstanding sale. Those are the 1, 2, 3, 4, 5 words that I want you to internalize. A security interest continues in collateral notwithstanding sale. That means that when a secured party has a security interest in something, for example, a robot in a factory, and that something, that collateral is sold, the security interest, the general rule is, the security interest continues in that collateral, even in the hands of the buyer. Okay, and this is what, so that's where we begin. And of course, it is a little broader than just sale. It's any kind of disposition, sale, lease, license, exchange, or other disposition. For example, if you have a security interest in a patent, and that patent is, which may be perfectly permissible, unless there's a contractual prohibition in the security agreement, imagine the debtor has this patent and licenses it out to a company or a couple of companies and makes $1 million. The security interest will continue in that patent. Nothing's happened to it. And we're going to find out later when we talk about proceeds that the security interest will actually apply to those proceeds, those receipts from licensing as well. Another example, though, is, so that's licensing, and there is no effect of licensing on the attachment of the security interest. But even sale, outright sale, when you sell it to some other buyer, the security interest still exists. So that's the general rule. Now there are additional rules. One that applies with respect to regular buyers and secured parties, and the other one applies to the buyer in the ordinary course of business and their relationship with other secured parties. And these are both priority rules. Okay, so first there's this, and this 9315 sets up the contest, because if we didn't have 9315 and the security interest didn't continue in the collateral when it was sold, then there wouldn't be a contest. Then the secured party wouldn't have security interest anymore and would have no claim to it, and the buyer would win. But that's not the rule. The rule is that security interest continues in the collateral even after it's sold, and then that gives rise to the contest, because now the secured party has a security interest in the collateral, and the buyer has an interest in the collateral, an ownership interest. It paid money for that collateral, and so neither party is to blame. They're both are engaged in totally ethical and proper transactions. The secured party taking a security interest, and the buyer paying money to own the collateral. So they're both very sympathetic characters. They did nothing wrong, but we have to pick a winner. The collateral has to go somewhere. And so the decision is encapsulated in these two priority rules. The first one we have looked at before, but let's take a look at it again. Never hurts, and that is 9317, which is the priority rule. So I closed it. I can recover it here. Oops. Bear with me as I struggle with the technology. We'll look at 9317. B, remember A is the priority rule with respect to lien creditors, but B is the priority rule for buyers. Here we go, a buyer, skip down, takes free of a security interest if the buyer gives value and receives delivery of the collateral without knowledge of his security interest. We've talked about that before, that the buyer can win and maintain the collateral if the security interest was not perfected and there was no knowledge. There are two requirements, both have to be fulfilled. Either of those are not true, that is, the security interest is perfected, or if there is knowledge, then the secured party wins. Okay, now 320. Let's look at 320, which is the priority rule for buyers in the ordinary course of business. And it's quite different. Here we go. A buyer in the ordinary course of business takes free of a security interest. So that's the big difference. But typically the buyer is going to lose under 9317B because all secured parties are going to be perfected. You know, unless there's some gross oversight, you know, every lender is going to file a financing statement and be perfected. And so buyers ordinarily lose, unless you get lucky. But buyer in ordinary course of business, they normally win. There's only a narrow exception that we'll get to as we when we get to the last problem on of the assignment today. So those are the two rules to know. Let's dive into the problems and put them to work. Again, the three things I want you to know so far are that a security interest in collateral continues notwithstanding sale or other disposition. It will continue in the collateral. 317B, that the priority rule between a secured party and a buyer is that the buyer wins if the security interest was not perfected and the buyer had no knowledge, prior knowledge of the security interest. And the rule for buyers in the ordinary course of business, and the general rule being you take free of the security interest. And we know that intuitively, you and me. Whenever we buy anything, what did I buy recently? A tank of propane tank for my grill, because it's time to grill. And I know that no one is going to come knocking at my door. No bank, no loan officer, no repo man, and saying, Mr. Sundahl, can you please bring the propane tank that you just bought from Ace Hardware? We're repossessing it because we have a security interest in their inventory. No, we know that would never happen, and that is in fact the law. And here you see why that doesn't happen. Because under the law, you take free of your security interests. The loan officer has no claim anymore. Okay, let's turn to, oops, I don't want to do that. Okay, all right, now we found where we're going. We're going to kick things off with problem 82. I assigned just the first two parts of it because after that, it kind of drifts off into Article 2, which is this is not the Article 2 class. So here we go. Let me share. Zoom wall. Okay. There we go. Problem 82. Betty Consumer bought a television set from Distortion TV Inc., a retail store. All right. Bells are going off. Sounds like a buyer in the ordinary course of business. A month later, Distortion went bankrupt, and a minor functionary from the Octopus National Bank showed up in her stoop and asked her to turn over the set. He explained that Octopus National Bank held a perfected security interest in all of Distortion's inventory, and that since Distortion had not paid off its debts to ONB, the bank was repossessing it. Hey, what should Ms. Consumer tell the bank's flunky? Get lost, right? Get lost. You no longer have a security interest in the television set, or I take free of it. You could look at it that way. She takes free of the security interest. In the event he can't enforce it and will have to leave. He has no right. Okay, let's go on from there. Would it matter if she had known that ONB had a perfected security interest in Distortion's inventory? Now we're looking at the question of knowledge. Does knowledge fit in? Does it figure into this analysis whatsoever? Because we know a regular buyer will lose if they have knowledge of the security interest before they make the purchase. Does that matter here? Let's take another closer look at language of the law. A buyer in the ordinary course of business takes free of a security interest created by the buyer seller. Aha, this is great language. Even if the security interest is perfected and the buyer knows of its existence. Do you see the lyricism that's going on here, the literary echoes? It's really beautiful because the ordinary rule for buyers is that the buyer will lose if the security interest is perfected or if the buyer has knowledge of the security interest. Buyer in the ordinary course of business, Rule 9320, turns that on its head and does so explicitly because it says the buyer takes free of the security interest even if it's perfected and even if the buyer in the ordinary course of business has knowledge of it. You still get priority over the secured party. So it's the exact opposite of the ordinary rule. Very cool. Good statutory drafting, I think. Okay, where else do we go with this? I think we were going to stop there. So let's go on now to 84. 83. Should be coming up here. 84. Octopus National Bank had a perfected security interest in all cars on Smiles Motors lot. Smiles owed $5,000 in past due insurance premiums to its insurance agent, Howard Teeth, who showed up one morning to buy a new car from Smiles. Okay, so we have this, we have Howard Teeth as the insurance agent, and Smiles owes him money for insurance premiums, I'm sure. And so the insurance agent, Howard, comes to the lot one day and wants to buy a car. But before they talk about the cars, the president of Smiles first gives Howard a check for $5,000. But Howard then endorses it back over to Smiles when he sees a new car he wanted to buy. Okay, so he first pays him off. The president hands him a check, and he accepts the check, and then sees this car that he wants to buy, and signs it, endorses it, and hands it over to Smiles, to the president of Smiles, to pay for the car. Okay. Is Howard a 201(b)(9) buyer in the ordinary course of business, so as to take free of ONB's security interest? Now, of course, the priority rule for buyer in the ordinary course of business is 9(3)(20). 201(b)(9), which we can turn to, is the definition of buyer in the ordinary course of business. Now, I've been defining that term in a nutshell as buying something from a seller that's in the business of selling goods of that kind. But there is a little more to it than that. So let's take a look. This is going to be 1/1/201. Yes, here we go. Buyer in the ordinary course of business means a person that buys in good faith. That should go without saying, in my opinion, because good faith is always required throughout the code. But yes, requires good faith without knowledge that the sale violates the right of another person in the goods, and in the ordinary course from a person other than a pawnbroker in the business of selling goods of that kind. So, that was the core of the definition. And I still believe it's the core of the definition. It has to be an ordinary course. That's a broad term, so that whenever something extraordinary happens, which may be extraordinary to some and not to others, but there's the room to litigate and argue. If there's ever something that's not ordinary about a sale, the seller can argue that, or the secured party can argue that it was the buyer is not a biocob, since a biocob is only generated if there's an ordinary sale. Okay. Those are the requirements. And so do we need to read further? I think so. So it goes on from there. It is a fairly lengthy definition. So let's read on. A person buys goods in the ordinary course if the sale to the person comports with the usual and customary practices in the kind of business in which the seller is engaged, or with which the seller's own usual, or with the seller's own usual or customary practices. Hope I didn't butcher that too bad, but this is just provides further guidance for what constitutes ordinary, and has two prongs. One, that it has to comport with trade usage, usual or customary practices in the kind of business, so general trade usage it has to comply with, and or with the seller's own usual or customary practices. Okay, so it has to be customary one way or the other. It'll either one will do, that it comports with trade usage or at least comports with the ordinary practices of the seller here, so that there are no surprises. Let's go on. A person that sells oil, gas, or other minerals at the wellhead or minehead is a person in the business of selling goods of that kind. Okay, that clarifies that this also applies to mining and wells. This is the operative language that we're really getting after in this problem. A buyer in the ordinary course of business may buy for cash by exchange of other property or on credit, whether secured or unsecured. That is, when you buy something, you'll still have a buyer in the ordinary course of business status if you pay cash, if you barter, or if you put it on a credit card, and may acquire goods or documents of title under a pre-existing contract for sale. Okay. Only a buyer that takes possession of the goods or has the right to recover the goods from the seller under Article 2 may be a buyer in the ordinary course of business. And that gets to not those situations that are not going and purchasing something and walking out of the store with it, but instead, for example, ordering something and then it is manufactured and it's put in the warehouse. At what point do you actually possess and own the product and can be said to be a buyer in the ordinary course of business? And the rule is as soon as you have a so-called insurable interest, and I don't think we've mentioned this before, but it happens, and I wouldn't test you on this. This is Article 2 stuff, but it happens as soon as the goods are tagged for sale specifically for a certain customer. So if you order 5 computers, you have a right in them and become a biocob, meaning that you will have a superior right to them in the case a secured party goes after them, as soon as the 5 computers are picked out and put on a pallet with a note that says, going to CompuCity, USA in Cleveland. Then you acquire these powerful rights as a buyer, biocob. Okay. Now we're finally getting to the operative language that's at work here in this problem. The last sentence here, buyer in the ordinary course of business does not include, this is an exclusion. You don't get the super priority of a biocob if the person acquires goods in a transfer in bulk or as security for or in total or partial satisfaction of a money debt. If you take goods, accept goods in exchange for canceling a debt, you're not a biocob. It's a policy decision. We could talk about why that is, but that is the black letter law. And here, the question is, when Howard Teeth hands over that check to Smiles, to the president of Smiles, it says, hey, I'm endorsing this $5,000 check over to you in payment for that beautiful car there. Is Howard Teeth a buyer in the ordinary course of business? And I would argue that he is, that the negotiation of the check over to Smiles is not cancellation of a debt. I would divide these two, bifurcate these two transactions. One that Smiles paid off his debt by handing the $5,000 check to Howard Teeth. So that was just a payment to pay off a debt. And then Howard Teeth had this check and endorsed it over as payment back to Smiles. And so they were, you could argue, I think it's the correct perspective, that these are two separate transactions and that Howard Teeth should have the priority rights of a buyer in the ordinary course of business. Now, the counter argument to that is that that's splitting hairs, and what we really have here is the paying off of the debt by giving him a car, and that this check thing that went back and forth, that really is splitting hairs. The core of the transaction was, or the effect of the transaction at the end of the day was that the debt was canceled. Smiles paid off their debt to the insurance agent, and the insurance agent has a car. So that looks like they acquired the car in cancellation of the debt that was owed by Smiles. But I think that is ignoring the facts that what we really had here were two transactions. They just happen to be very close in time, and so a cunning lawyer might want to collapse the two. But I would reject that analysis if I were the judge. Okay, let's go on from there. That's 84, and we are off to 87, right there. Andy Audio. Let me take a little sip of coffee here. Andy Audio bought a stereo. Andy Audio bought a stereo receiver on credit from Voice of Japan Inc., an electronics store, giving it a purchase money security interest in the receiver. Okay. Andy bought the receiver on credit from Voice of Japan and granted Voice of Japan a security interest in the receiver. Okay, and it's a purchase money security interest, of course. Voice of Japan did not file a financing statement. As we all know, that's not necessary if it's consumer goods. This stereo, or for Andy's, he's taking it back home, not taking it to his business office. Then there'd be automatic perfection on the purchase money security interest. Okay, so he didn't have to file a statement. 6 months later, when Andy still owed Voice of Japan $300, he held a garage sale and sold the receiver to Nancy Neighbor for $200 cash. Now, if Andy stops making payments to Voice of Japan, can it repossess the receiver from Nancy? See 9-320B in official comment 5. Now, this provision has traditionally been referred to as the yard sale rule or garage sale rule. I like to think of it now to update, and this is kind of showing my age. I would call it I did for a while, call it the Craigslist rule. But now people are using Craigslist less, and at least from what I see, the secondhand goods market is largely on Facebook Marketplace. So we could call it the Facebook Marketplace rule. Whatever it is, it's the private sale of used goods. The private sale from one consumer to another consumer. No businesses involved as either the seller or the buyer. And there's a special rule that applies there. And it's a 9-320B, and it basically protects buyers in a garage sale setting. Okay, and I think it must have had its roots just in practice and expectations of parties and the custom of all Americans to go to yard sales. And would it be right to give creditors the upper hand and be able to seize things from you that you bought in a yard sale? Let's look at the rule and see how it's treated differently than either the 9-317 or the 9-320A, the buyer in the ordinary course of business rule. So this is a third rule that I want you to know for situations involving buyers. You want to know the fundamental provision, 9-315. That a security interest continues in collateral upon disposition. And then you want to know the BioCob rule, 9-320A, the regular buyer rule, 9-317B, and now this, the yard sale rule, or the Facebook Marketplace rule of 9-320B. Let's take a look at that rule. Let's take a close look at 9-320B. There it is, buyer of consumer goods, the yard sale rule. A buyer of goods from a person who used or bought the goods for use primarily as personal, family, or household purposes takes free of a security interest, even if perfected, if the buyer buys without knowledge of the security interest, for value, primarily for the buyer's personal, family, or household purposes, and before the filing of a financing statement. All right, how do we make sense of this? There's a lot of pieces. How do we fit this together? Well, first of all, this applies to transactions from one consumer to another. So first of all, the goods being sold have to already be consumer goods. They're not inventory on a store shelf. They have to be consumer goods. So that's typically what happens at a yard sale, right? You have used personal items. So that's the first element. Where does it say that the buyer has to also be a consumer and will use these goods for personal household purposes? It says it down here. This will apply if the buyer buys primarily for the buyer's personal, family, or household purposes. So those are the two elements that establish that this transaction is between two consumers. And what does it say? That buyer takes free of the security interest. That's the core. And in this situation where you have two consumers buying from each other, the buyer is going to win. That's the general rule. And that's the rule that we all are familiar with and that we expect, that when you buy something at a yard sale, you buy something secondhand, that you are going to have superior title to that, that there's no bank is going to come and try to repossess it because of a security interest. So that's where this statute states that in that consumer to consumer sale, the buyer takes free of the security interest. And then let's go on and read a little bit more into it. That you're going to win in a yard sale if you're the buyer, even if you're perfected, even if it's perfected. You're going to defeat that secured party. Now, let's contrast that with the typical rule. Let's apply, let's see, since it's not a buyer in the ordinary course of business, it would just be, if, you know, and we're thinking about the state of the law without 320B, what would be the rule that would apply at a yard sale? Well, it wouldn't be a buyer in the ordinary course of business because the seller is not in business of selling goods of the kind. It's not a retail situation. So the applicable rule would be 317B for regular buyers. And what's the rule there? That the buyer is going to lose if the secured party is perfected. So if we didn't have 320B, that would be the result. Then in a yard sale, if the secured party was perfected, the buyer would lose to the secured party, be able to take it from the buyer's hands. And that would mean, because when you have a purchase money security interest in consumer goods, you get automatic perfection, which means that in every case, we can assume if we're dealing with consumer goods, the secured party will have a perfected security interest, and under 317B would therefore win because you get automatic perfection. So that would be the existing law. And of course, none of us want that or expect that. That's not our custom. And what we expect if you buy from a yard sale, you don't expect that a bank is going to come and seize it. So to apply 317B would be unjust from our traditional perspective. And so we needed a special rule to adjust the law for this narrow situation where you have a consumer buying from a consumer. So, and under this, this rule then, 320B, that it allows the buyer at a yard sale to defeat the secured party, even if they're perfected. You know, it reverses the 317B rule, which says that if the secured party is perfected, they win. Here, the buyer is going to win even if the secured party is perfected. Gives a lot of protection. The buyer just can't have knowledge of it. Has to pay something for it. It's for value, and buys it for personal use. So you're going to win at a yard sale, regardless of whether the secured party, be at Best Buy or Walmart, where the seller bought the goods, even if they're perfected, you're going to win as the buyer at a yard sale, as long as you don't have knowledge of the security interest, which you typically wouldn't, unless you're told. You got to give some value, and we all do, whether it's $1.50 or maybe for a used television, it'd be $100. And of course, it's got to be for your personal use. So you're generally going to win at a yard sale unless you have knowledge of the security interest. So that's kind of the shape of B. And then there's this last provision, the filing of a financing statement to cover the goods. What is the purpose of that? That is a tool for the secured party to protect itself from this rule, because it's a pretty harsh rule from the perspective of Best Buy or Walmart, who sells things on credit. They're going to lose. They're not going to be able to seize that that collateral, which is going to be the only collateral most likely for this obligation to pay, they're going to be cut off and not be able to seize it if the debtor turns around and sells it at a yard sale, which is very easy to do. If the debtor, is short on cash, needs to generate $100, let's sell my new TV. And then the Best Buy, the secured creditor, would be cut off. So it's a dangerous situation for retailers that sell on credit. But there is something that could be done. They can file a financing statement. And remember, financing statement typically would not have been filed because you get automatic perfection in the purchase money security interest in consumer goods. So usually there isn't a financing statement filed. And therefore, yes, the buyer at a yard sale will always win. But if the secured party is really concerned about this, and for example, if it's a high dollar item, they can protect themselves from the harshness of this yard sale rule by filing a financing statement, which isn't that difficult, but it typically isn't done for the sale of consumer goods. But if you face this situation, if you're concerned about the debtor turning around and selling it at a yard sale, which is a valid concern, anyone could do that, have the file a financing statement against the debtor. Okay. Now let's turn to problem 87. So Andy Audio, I bought this stereo from Voice of Japan, and then it turns out that Andy sold it at a garage sale to Nancy. And then he defaults on the obligation of Voice of Japan. Can Voice of Japan turn around and knock on Nancy's door and repossess it? No, they cannot. It would have, the security interest would have been perfected automatically. So Voice of Japan did have a perfected security interest, purchase money security interest in the receiver. But under the yard sale rule in 9320B, Nancy would win. It doesn't matter if it's perfected or not, as long as it was consumer goods and Nancy's buying it for personal use and pays something for it and doesn't know about the security interest, Nancy's going to win. So she's fine. She's covered. What should Voice of Japan have done to protect themselves from this? They could have filed a financing statement, and then they would have been able to knock on her door and say, please bring me the receiver. We're here to repossess it. And if she didn't do so, then they would go to court and explain that they have the right to repossess the receiver, and they would provide whatever documents are needed, and the court would issue an order to Nancy to give up the receiver. So that's how that would actually play out. So that's 87, 89 right here. Paul Pop. Paul Pop was a rock singer to whom Octopus National Bank loaned $8 grand so he could buy stereo equipment for his road show. Okay, ding, ding, ding. That makes me think of a purchase money secured party, an enabling loan. They gave Paul Pop money to buy the stereo equipment, and I'm assuming they took a security interest in it. Let's see. On April 2nd, Paul purchased the equipment, and on April 10th, ONB filed its financing statement in the proper place. Okay, so yep, it was a purchase money security interest, enabling loan. April 2nd was the purchase and the signing of the security agreement, I imagine. And then 8 days went by. April 10th, they filed their financing statement. Okay, why do they need to file a financing statement here? Because it's not consumer goods. It's for business use. He's Paul Pop, the rock star. So the use of this equipment is for commercial purposes. And so if they want to perfect their security interest, they have to file a financing statement. But they did that on April 10th. However, in the interim, on April 8th, Paul sold the equipment to Use Stereo Heaven. which bought with no knowledge of the bank's purchase money security interest. Does ONB or used Stereo Heaven have the superior claim to the equipment? Okay, so what do we do here? We see, let's identify the parties and apply the appropriate priority rule. I say that always works, so let's give it a try here. Let us identify the parties. We have on the one hand, a purchase money secured party that is perfected on the 10th, as of the 10th, when they filed a financing statement. And what is used Stereo Heaven? Is it a buyer in the ordinary course of business? No, because Paul's not in the business of selling stereo equipment. And so they're just a regular buyer. And they don't have knowledge of the security interest, so it's a regular buyer. So what we've now identified the parties, one a secured party, the other one a regular buyer. What's the appropriate priority rule? It's 317B, which says that the secured party is going to win. There's Octopus National Bank is going to win if either they are perfected before the sale, or the buyer has knowledge of the security interest. Here, there's no knowledge, so that's not a problem. So the question here is, does Voice of Japan have priority over this buyer? And under the ordinary rules that we know so far, it would be 317B that would apply. And the rule is, of course, the secured party will win if it's perfected or the buyer has knowledge of the security interest. Here in this case, there's no knowledge. And it appears, and there's also no perfection. So it would appear that the buyer should win. Used Stereo Heaven should win because it didn't have any knowledge of the security interest. And when the purchase was made on the 8th, the security interest was unperfected because Voice of Japan didn't file until the 10th. So under 317B, Used Stereo Heaven should win. But do they win? No. And that's because there was a special rule made for purchase money secured parties. This is another benefit to being a purchase money secured party. The first one is that you defeat all conflicting security interests if you do what you're supposed to do. But the second one is you defeat buyers and lien creditors, even if you're unperfected. And let's take a look at the rule which establishes that. That is 317E. There we go. If a person files a financing statement with respect to purchase money security interest before within 20 days after the debtor receives delivery of the collateral, the security interest takes priority over the rights of a buyer, lessee, or lien creditor, which arose between the time of security interest attaches and the time of filing. Okay, so to boil that down, there's this the 20-day, there's a 20-day grace period basically to file a financing statement. As long as you file within that 20 days, you are going to defeat a buyer that purchased the collateral between attachment and filing. So that's what we have here. Okay, so that's the special rule for purchase money secured parties, that even if the collateral is sold to a buyer before perfection, the purchase money secured party will win. But you do have to file within 20 days. If you don't file within 20 days, then you are going to lose to the buyer. But if you file within 20 days, you will have priority over a buyer that made the purchase between moment of attachment and the moment of filing. So here we have filing on April 10th, which was within the 20-day window, and therefore we have Used Stereo Heaven win. Now, the moment we've all been waiting for, problem 92. Let's wrap up this assignment on buyers. And what more do we have to explore? We're going to take a closer look at buyer in the ordinary course of business. And I want you to focus in on particular language that I kind of glossed over when reading the provision 9320A last time, because it goes something like this: that a buyer in the ordinary course of business takes free of a security interest created by the buyer seller. Interesting language. What does it mean? Sounds rather circular. But the buyer takes free of security interest created by the buyer seller. Well, let's look at the language. Come on, 320 again. There we go. A buyer in the ordinary course of business takes free of a security interest, and this is the language, created by the buyer seller. What does that mean? It's actually a limitation on the operation of the buyer in the ordinary course of business. So I would look at it as an exception to the rule, or a possible exception to the rule. There are certain situations where the buyer in ordinary course of business does not take free of the security interest. It only takes free of the security interest created by the buyer seller. That is, created by the party that's selling the item to them. It takes free, the buyer in ordinary course of business takes free of security interests that were granted by that party, by their immediate seller. If the security interest was created elsewhere, was granted by someone else, then the buyer in ordinary course of business super priority does not apply, and the BioCob will be subjected to another party's security interest. So you could potentially face a situation where you buy goods at a retail store on credit, and another party, when your seller goes bankrupt, another party comes and actually can take the property, the goods out of your hands. Normally, if you buy retail, you take free of all security interest. You don't have to worry about the knock at that door. But there are some situations where you may face the knock at the door. And that is if the security interest was not created by your seller. And problem 92 illustrates this rule. Let's check it out. Okay. Let me share the screen. Okay, there we go. Mr. and Mrs. Halyard purchased a large sailboat. Sounds nice. Purchased a large sailboat with money borrowed from Boilerplate National Bank, BNB, which took a security interest therein and promptly filed a financing statement in the proper place. All right, so Boiler National Bank, it is a purchase money secured party. It's an enabling loan, right? The bank made a loan for the purpose of buying a sailboat, and then took a security interest in that very sailboat. Okay, and then they promptly filed a financing statement in the proper place. All right, did they have to file a financing statement to be perfected? No, this is a consumer goods in the hand of the Halyards, and it's a purchase money security interest in consumer goods, so they're automatically perfected. But nevertheless, the secured party filed a financing statement, and as we have learned, that's a good idea, even if you get automatic perfection, because you protect yourself against the yard sale buyer. So they filed a financing statement, they are perfected, double perfected. The Halyards sold the boat to Oil Slick Boat Sales, a used boat concern, telling Oil Slick of the bank's interest and of the necessity of making monthly payments to the bank. Okay, so now they sold it to a used boat store. Very good. Would the used boat store be subject to the security interest? They would. They'd be subject to it. The yard sale rule doesn't apply because Oil Slick is not using it as consumer goods. It's going to be their inventory. So the art sale rule doesn't apply. So it's just a regular buyer rule. And in a regular sale, the security interest is going to continue into the hands of the buyer. So
Right.
now, if the problem ended with the sale of the sailboat to Oil Slick, then it would be a very easy question. Imagine that the Halyards sold their boat to Oil Slick, and then the Halyards defaulted, stopped paying the bank. The bank would win, right? It would just be it would be under the 317B rule because the Halyards are not buyers or not merchants with respect to goods of the kind. So it would just be the regular buyer rule, and Oil Slick would lose because the bank is perfected. So that would be very easy, but the problem doesn't end there. The problem is about the blinks. Now, so Oil Slick purchases the boat, and the security interest continues in the boat in the hands of Oil Slick. And now Oil Slick resells it to the blinks. And then the Halyards default on their loan to the bank. And the question is, does the bank still have the ability to repossess the sailboat from in the hands of the blinks? And well, now you ask yourself, okay, what are we dealing with here? A regular buyer, the blinks? Because the bank is still a secured party. You know, what are the two, how do you characterize the two competing claimants, right? The bank is still the secured party versus the blinks. The blinks are buyer in the ordinary course of business, right? Because Oil Slick is in the business of selling used boats. So and all the other requirements are met. The blinks are buyers in the ordinary course of business, but even though they are biocobs, they lose to the bank. And that's because the security interest was not created by the blinks seller, which is Oil Slick, their immediate seller. Those are the only security interests that they take free from. Who was the security interest created by? The Halyards, right? Not their immediate seller. And so they don't take free of the security interest, and the bank can seize the sailboat and sell it to satisfy the obligation owed to the bank by the Halyards. Does that leave the blinks without a remedy? No, that's just the story under Article 9. The blinks still have a remedy, and that is they would sue Oil Slick under the breach of the warranty of title, which is automatically given under Article 2, 312. Whenever something is sold, whenever goods are sold, the seller grants to the buyer a warranty of title, which states that the buyer will receive title, good title to the goods after the sale. That is that the seller owns them and can transfer good title. But there's something more that is part of the warranty of title. Not only that good title will be transferred, but that the goods are free from any security interests. And since they are not, in this case, that would be a breach of Oil Slick's warranty of title. And so the blinks could sue Oil Slick, get their money back. And so Oil Slick is then the loser. And they have, they could sue the Halyards in turn for breach of their warranty of title, because the Halyards made it as well and they sold it to Oil Slick, and then it turns out to be subject to security interests held by the bank. And if Oil Slick could collect, great, then everyone's made whole. But they probably won't be, because the Halyards, remember, just defaulted on their loan to the bank, and so they don't have any money. So it's likely that Oil Slick will be the losers. And is that fair? The answer is, and this is the way that that question is usually looked at, is that the ones who lose should be the ones who had the ability to prevent this from happening in the first place. And that was Oil Slick was in the best position to make sure that there wasn't a security interest in this boat, Maybe they could have required that the obligation to the bank be paid off before they bought the boat from the halyards, or made some other arrangement. But they didn't, so they took this risk and they paid for it. So that's the end of assignment 11. I'll see you for assignment 12.